Oh, we're going to go back to the court. There's nothing.
Okay, Mr. Zimmerman, please stand up. I'll remind you, sir, that you're still under oath from when we had you sworn in earlier before the break. Did you now have sufficient time to discuss with your attorneys whether or not you wanted to testify in this case?
Yes, Your Honor.
And I don't need to know what was said, but after those discussions, have you made a decision?
Yes, Your Honor.
And what is your decision, sir?
After consulting with counsel not to testify, Your Honor.
Okay, you understand that no matter what counsel says to you, it's still your decision. Do you understand that?
Yes, Your Honor.
Okay, and I need to know, is it your decision to not testify in this case?
Yes, Your Honor.
And are you making that decision freely and voluntarily?
Yes, Your Honor.
Has anybody promised you anything to get you to make that decision?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
And this is clearly the decision that you yourself have made.
Yes, Your Honor.
Thank you very much. Is the defense going to rest subject to any more evidence being entered?
That's correct, Your Honor. Thank you.
Is the state going to have rebuttal evidence? Testimony?
Yes, Your Honor.
And how many witnesses are you going to be calling for rebuttal?
Have at least 2 today, and one who is not available today should be available tomorrow, which we may not end up calling anyway.
Okay, I still haven't seen the proposed jury instructions. It's my understanding that a copy has been provided to the defense and a copy has been provided to Mr. Zimmerman. Is that correct, sir?
Yes, Your Honor.
Okay. Can I please have a copy? Are these 2 witnesses going to be lengthy?
I don't think so, Your Honor.
Can we do a charge conference after we excuse the jury for the day?
I don't see a reason we can't.
We can start. We have some special jury instructions to prepare and present, but we can at least get a feel. I think might now be the time for me to renew my judgment of acquittal.
Right, and then you'll rest in front of the jury and we'll go forward.
Yes.
Okay, you may proceed. Yes. I'm sorry, yes.
No, I think with the length of the presentation to you earlier, I'm going to certainly abbreviate and not readdress the arguments nor the case law that I addressed. I would certainly ask you to reconsider those. I think that the factual basis, however, has changed somewhat, and I'm not going to recount it because I know that you were sitting here along with us during the whole time of hearing it, but that the defense case has presented now evidence that I believe, uncontroverted evidence, that supports my client's contention that he acted in self-defense. That includes, of course, the most recent witness, Mr. Root. It includes Dr. DeMaio and his expert testimony in regard to the gunshot, and also the other information concerning the injuries that my client suffered. We also have a number of voice witnesses, if you will, those witnesses who have come back and testified before this court that they had no issue whatsoever and were quite firm in their position and belief and testimony under oath that it was my client who was screaming for help. And again, I don't want to belabor the point of the previous case law, but I think that you would need to decide at this point basically that there is that the state has excluded at this point in the trial a reasonable hypothesis of my client's innocent, and now with the strength of the defense presentation that they have failed to do so, and I would ask that the charges be dismissed in full.
Response?
Thank you, Your Honor. If anything, the state's position is that Dr. DeMaio certainly portrayed at least one alternative scenario where the defendant could absolutely have committed second-degree murder against Trayvon Martin, just by virtue of his answer to Mr. Delarianda's questions, that being that Mr. Martin was attempting to pull back or disengage when he was shot and murdered by this defendant. Moreover, to say that Mr. Root's testimony was uncontroverted is, I think, overstretching it even more than Mr. Root did. Certainly he was very eager to draw conclusions, but he also had to admit finally that he had absolutely no idea what exactly went on at the moment that this defendant shot and killed Trayvon Martin. So we believe that while the defense may have presented people to sort of enhance the dispute of facts and the inferences that can be arisen, in other words, to make it perhaps even more disputed, that the state has certainly submitted sufficient evidence and will again continue to do so in rebuttal to indicate that both the facts and the inferences that can be drawn therefrom would support a jury verdict as to both murder and the lesser included manslaughter.
Very brief response. I would just ask that either the state or perhaps the court, if you're going to rule, identify the state's factual scenario, their theory of the case, anything for which there is that excludes a reasonable hypothesis of innocence of my client now that they finished their case and we've finished our case. I would ask that that be articulated in some form or fashion, either by the state so that you can make the ruling or by the court in your ruling that actually suggests that legally this judgment of acquittal should not be granted.
Okay, thank you. The court has sat here and listened to all the witnesses. I think I had previously said how many witnesses had testified both on behalf of the state and the defense, and have listened to the arguments both at the end of the close of the state's case and now at the close of the defense case. And the court's decision is the same, that there is substantial evidence, both direct and circumstantial to allow this charge to go to the jury. So we need to bring the jury back in. You need to rest in front of the jury, and the state be prepared to call your first rebuttal witness. Let's go. Are we ready to bring the jury in?
Is there a chance of finding out who the rebuttal witnesses are so we can see if there's discovery issues or...
Yes, and then we have to, at some point in time, deal with the Mr. Donnelly issue. We could do that after we've talked about it. Who's the witness that you're going to call next?
First one will be Adam Pollock.
Right, and can you tell us who the second one is going to be?
David Lee.
David?
Lee.
Thank you.
Okay, they had a third. I just didn't know if we...
They didn't know if they were going to call that person tomorrow or
I
not.
have to ascertain his certain availability, Your Honor. I just haven't.
When you find out tonight, would you please email the defense and let them know so they could be prepared for that in the morning?
Yes, Your Honor.
Thank
And I
you.
know the state understands that they are bound in true rebuttal. Mr. Pollock testified before. I want to make certain this is not just a re-examination of him, but it is truly in rebuttal to some particular fact that we presented in our case.
If it's not, you're free to object, and then I'll roll.
Yes, Your Honor.
Are we ready to bring the jury in?
The defense is... Yes, Your Honor.
Okay, you need to again rest on the record
I will do that.
in front of the jury. I mean, please bring the jury in.